Hello, this is attorney John Montague. I wanted to prepare a short and brief video regarding sort of what goes wrong with a contract, at least as it applies under Chapter 672 of the Florida UCC. This is primarily directed towards founders and entrepreneurs. I myself was, in a prior life, an entrepreneur that dealt with goods in transit of goods with large amounts of money in inventory. And so I think this is useful to entrepreneurs that may be under the UCC merchants that are selling or buying large amounts of goods or inventory. And so with that in mind, we'll just get right into it. So as I said, this applies to the Uniform Commercial Code, which Florida adopted in 672 of the Florida statutes. Of course, you don't generally care about the statute number. You're going to kind of say, in any sort of situation, you're going to be using your business mind. What can I walk away from this deal? What money can I get back? Can I force the other side to perform? And can I get compensated later down the road or downstream due to damage of my business? The law basically, and this is common law, which is primarily tested in all jurisdictions on the bar exam. So there's going to be a lot of overlap if you're a lawyer between this and what you may have studied in first year contracts. However, I understand not everybody goes to law school or wants to go to law school. And in some ways, law school is not the best use of time. So I'm going to try to distill down what these remedies are in a brief period of time. First, when you're a buyer, this is if you're buying goods for your business, raw materials, inventory, custom equipment, this kind of thing. If the seller completely fails to deliver, delivers late, or delivers non-conforming goods, you generally have 5 levers that you can pull on to get remedies and get your money back. The first is pretty simple and easy to understand. Cancel and you get your money back. If the breach is serious enough, especially under installment or a long-term supply contract, you can cancel the contract and recover payments you've already made for the undelivered or defective goods. The second is cover. Cover is a UCC word for get replacement goods from someone else. You can buy reasonably similar goods in good faith. So this allows you to actually go out and buy substitute goods. And basically, what you can recover is the difference between what you had to pay and what the contract plus price was, plus incidental and consequential damages. In founder terms, you fix the operational problem and you keep your legal rights intact. 3 is market damages. If you don't or can't cover, there's another formula, the market price at the time and the place of tender minus the contract price plus incidental and consequential damages. Incidental and consequential damages as well, to kind of summarize, you can think as like, legal expenses, shipping goods, maybe travel, if you're going to source the goods, things that are incidental to which you're getting. Consequential damages may be things that you can't reasonably foresee, but occur as a result of the breach. An example of this would be you didn't get the goods and you miss out on a big contract, so you can actually get those consequential damages due to you not being able to perform the contract. Specific performance and replevin. This is generally applies to unique goods. And you may be able to ask the court for specific performance. Replevin is similar. It's about getting physical possession of the goods that you have identified in the contract. I would generally say that in order to use replevin, you actually do need to have the goods specifically identified, ideally with a number or a count or something. And in an ideal situation, yeah, you want those specifically identified goods. Reject, accept, or revoke would be the 5th lever. When goods come in and they're defective or non-conforming, you can reject them within a reasonable time. You can accept them and sue them for damages. If you discover a serious problem later, you may even be able to revoke the acceptance if the defect substantially impairs the value and either you thought it would be cured or was hard to discover up front. Okay. Um, Now let's kind of flip the roles. We went through the five different levers as a buyer. Let's go through the five different levers of a seller. If the buyer has accepted the goods and just hasn't paid, you can sue for the full contract price, resale and damages. If the buyer wrongfully rejects, you can resell the goods at a commercially reasonable way and then recover the difference between the contract price and the resale price plus incidental damages like storage and shipping. Lost profit or lost volume for sellers. If you've a lost volume as a seller, for example, you had plenty of inventory and you could have sold to both the breaching buyer and a new buyer, you may be able to cover the profit you lost on the original deal, even though you resold at the same price. That is, you can, you know, get the profit that you lost back due to a difference in price, or I would say a difference in quantities. So it's kind of lost profit or volumes for sellers. Reclaiming and stopping goods. You may have the right to reclaim the goods within a certain period of time. If the goods are in transit, you may be able to stop delivery and require payment before release. So, you know, that's the sort of situation. You haven't got paid, the goods are out in transit, they're in breach of the contract, so you stop delivery. Pretty simple. Um, so now there's another thing that I'd like to discuss. We went through the five levers of buyers and the five levers of sellers. So I'll just repeat those for buyer: cancel and get your money back; two, cover; three, market damages; four, specific performance; and five, reject, accept, revoke. And you can flip that on the seller, and that would be action for price, resale and damages; lost profit for volume sellers, or lost volume for sellers; reclaiming and stopping the goods. So there's four levers. And then the last thing to kind of go over is there are two pieces that founders should have on their radar with respect to risk of loss and equitable remedy. Is first, on the risk of loss, who eats the loss if the goods are destroyed and damages? This was stressed when in my business law class by Professor Copeland, but this depends on the contract structure, shipping, like FOB destination versus just FOB. And it's also determined on if it's merchant and non-merchant. So there are some complexities, but that's something to get on your radar whenever you're working on a contract. I'm not going to go through all these different nuances because this is intended to be a short video. But always be thinking about risk of loss and security whenever you're dealing in the sale of goods. Last thing to discuss is equitable remedies. And I'll just kind of go through the three main ones that I'd like to discuss now. That's reformation, rescission, and cancellation. Reformation is when the written contract doesn't match the deal everyone agreed to, and you need the court to fix the language. Rescission is unwinding the deal entirely, like for something like fraud. And cancellation is under the UCC, ending the sales contract because there's a material breach while preserving your rights to damages. And sometimes you can even file a declaratory judgment in the event that somebody's reading the contract differently. This is basically asking the court to determine the language. And although I've don't have any declaratory judgments at the moment, that is a tool that I try to keep in my back pocket and arsenal with respect to litigation strategy. So kind of that concludes the video. The bottom line, contracts aren't just paperwork. They're, part of your business. You can think of them as part of your software or ecosystem. Whenever a deal starts to wobble, you want to be looking at your remedies under Florida law or wherever you may be based. Those generally want to look at the UCC. If you're applying with goods, if there's a broken contract and you're deciding what to do next, it's usually the right time to get a business lawyer involved. So these things, like anything else, are generally always solved easier the earlier you get a lawyer involved. That's not to say you need a lawyer on every contract, but and if I could stress one thing of importance, the one takeaway would be make sure you understand where risk of loss is allocated when your goods are in transit, because that can result in a lot of money. But yeah, feel free to reach out. My website's montague.law. And this is something that I've been revisiting recently, so I wanted to make a short video about it. And let me know if you have any questions. And that's John, and I'm with Montague Law. Bye.